Hi, my name is Zora Camilla, and I'm a fellow at Yale Law School. And I had a question for Mr. Hoffman and Mr. Day. If you could just comment on the case against Chevron in Ecuador. I know that's not a very pleasant topic, but I want to try to put aside the controversial plaintiff's lawyer, Stephen Donziger, who was at the center of the case, and just ask you if you see any lessons from that experience, given Chevron's inconsistent and perhaps even hypocritical actions, where they got the case thrown out of New York court by agreeing to submit to jurisdiction in Ecuador, only to now be bitterly fighting the enforcement of that Ecuadorian judgment. Thank you.
I think that the Chevron's tactics have inflamed a lot of people in terms of the way they've gone after everybody that had anything to do with that, and the hypocritical nature of the fact that they had it moved to Ecuador and then now they're fighting the judgment. I don't know how all that's going to turn out. I mean, there's a judgment against the lawyer, and that's going up to the Second Circuit, and we'll see how that plays out. What I would say is that there is a genre of case like that case, toxic tort cases against companies that have left destruction in their wake in the Amazon, for example, where I've been involved in one case where I can't really say who it's in. We're under a confidentiality order. I can't really say what we did or how it happened and all that. But what I can say is that this particular company decided, instead of fighting us, to actually settle the case and to give some compensation of various kinds to the community. And that's a different, I mean, you don't hear about that. You hear about the big judgment and the problems with Chevron. There may be some other examples that are happening that I don't think the companies really want to publicize, where they're trying to work out ways of not spending 50 million pounds or dollars litigating and giving that money to the communities. Now, of course, what they really need to do is deal with those problems when they're happening rather than 20 years after the fact, right? But if you, no matter whether they're dealing with it at the time or after the fact, hopefully the kind of work that Martin and I do will lead to those kinds of resolutions. And that particular process actually was very respectful of the indigenous people involved. It was not, I mean, it was difficult to be in the same room with people you're usually fighting with and then trying to find ways to actually talk to one another. But I found it to be a really optimistic turn of events. Now, I don't know if it'll continue to happen, and I know it's kind of off point from your question, but I'm hoping that the focus will stop being on this particular judgment and the fraud and what Chevron's doing, and trying to solve the underlying problem, because the people involved in the Ecuadorian judgment suffered horrendous harm, right? I don't think there's any doubt about that. And unfortunately, with all the debate about whether the lawyer did fraudulent things or anything else, they're not getting any help, and there's this big fight going on. And it would be much better if they just, stopped all that and got some relief to the people that actually need it.
Yeah, I have two questions. One for Michael Addo, and I was hearing what you said, and you mentioned bad practices, and it's actually what we've been hearing in France from companies. And I was wondering whether the UN Working Group would be able or willing to speak about violation instead of bad practices.
I think the question that was directed to me was more about language, and the language of violations rather than bad practice. And I think there's been a very long debate, not during my time, but during Ragi's time, about whether we could talk about corporate responsibilities or corporate obligations. And I think the relationship is between violations and obligations. You have, and the international lawyers will correct me, if you have an obligation, there's a breach of your obligations, and then you have a violation of an obligation under a treaty and so on and so forth. And that debate is going on as to whether companies have obligations under international law. Ragi took the position that no, they didn't. They have responsibilities to respect human rights. So that comes with the language of their activities have adverse impacts rather than violations. And I think we've adopted the same kind of language. I'm sure the subject is being revisited by academics all over. There was a recent conference in, where is that, Turku? Is that Norway? Finland, on this big issue. And they're still thinking about it, and the subject of personality of the corporation and access to treaties and so on and so forth. Who knows, maybe the Intergovernmental Working Group might come up with the kind of treaty which actually defines obligations.
And also, I mean, I would very much agree with Martin Day and Paul Hoffman about, doing litigation and suing and suing and suing. This is what Sherpa is doing. But also, in most of the European countries, legislation sometimes is not enough, domestic legislation, and that's why we are using soft law instrument like the OECD guidelines. But then the argument is bounced back to us, and they say, why do you ask for hard law when soft law instruments are, more efficient in certain cases? So I would like to have your answers or comments on this point. Thanks.
First of all, Sherpa, fabulous organisation, totally supports all you do, it's cracking. Two things about soft law. In my firm, my team know that I hate them doing anything to do with soft law. NCP, it drives me mad, because my view is that our job is to sue, and sue again. Did I mention that before? And there are lots of other people who can get involved with NCP points and OECD guidelines stuff and all that sort of stuff. There's lots of people, but there are not many people who are actually around who are good litigators. And hopefully I've accumulated them in my team. So I don't like them wasting their time with all that stuff. I'd much rather getting out, taking them to court.
Thank you. And any other comments from either of you?
By the way, I don't think the guiding principles are soft law, but I mean to say there is room and a place for everything. The hard law cannot do everything, and we know that. So there must be space for something else. And I think if it's called soft law, we should use it. We must use any opportunity. Outside of Martin's, there must be more than 60 lawyers in this world, and the 60 that want to do hard law, we'll let them do it. The rest should do something else.
I agree.
Mauricio from the Human Rights Resource Center. A question for Paul. Paul, I wonder if you can expand a little bit on the new avenues for redress that you mentioned. I wrote down trafficking, anti-terrorist legislation, but if you can be more specific on which legislations are you guys using in the new avenues for redress, and what are the possibilities open for victims' extraterritoriality in the US at the moment?
We're starting to look at other vehicles to do the same things, and those are the most obvious ones. But which is not to say that we don't think we're going to hold on to the Alien Tort Statute, because I still believe that there's going to be something left at the end of the day of the Alien Tort Statute that can be effective, at least against U.S. companies. I think that the days of suing foreign multinationals in the United States for extraterritorial violations is probably over. But I think U.S. citizens, U.S. corporations are in a different situation with respect to the purposes of this act to begin with, which were to have U.S. courts enforce international law in the United States. And I think it fits in terms of bringing cases against corporations. And I still believe the Supreme Court will see it that way. So we'll see.
And just to quickly add on to that, what was very interesting chatting to Paul over the last couple of days is how similar our kind of paths tread, because we've just been looking at trafficking ourselves, obviously a reflection of society that Britain is obviously seeing trafficking in a way that we've never seen before, and we try and respond to that in the way that I'd said earlier, bright people, we find routes to take them on, but also in the UK, we're also starting to look more at abuse cases relating to foreign companies who've got people who can hide under the company umbrella and abuse kids particularly. We've got a big case against British Airways about one of their guys who supposedly was going out on all this charity stuff and actually was ending up abusing the kids they were supposed to be helping. So, I think, as we're saying, there's lots of different routes, and part of our job is to be out there and finding ways to take on British, my instance, British entities, wherever they may be, if they're doing bad things.
Thank you. Question at the back over there.
Relates really to company grievance mechanisms. Given that we're in a situation where there are not many options for victims, we obviously need to have a multiplicity of different routes for accessing justice. So that is good. But the UN guiding principles is obviously leading to national action plans. And when national action plans such as ours include a specific reference that companies should have company grievance mechanisms, and unfortunately this is being promoted by our Quango that is all about trade promotion, a little bit weak on its human rights expertise, possibly. It might be useful for the UN Working Group to have some views on this, because it is a direct fallout from the promotion of the UN Guiding Principles. So I was thinking that, basically the fallout of the UN Guiding Principles is we have national action plans that may have unfortunate outcomes where company grievance mechanisms include gagging clauses. Mm-hmm. That's the real concern, that the company grievance mechanism closes down the possibility for multiplicity of different routes. So that's one element to sort of ask you about, and I think it would be really wise for the UN Working Group to have some comments on that. And the second one, obviously, I would say is the relationship between commercial practices and human rights. And I'm highly concerned also about the increase of trafficking, and I would argue that it is a direct consequence and not a surprise that it comes from a relentless pressure on price for cheap exploitable labour. And so there is a need to recognise that, and I think it would be very valuable to do that. And I notice it in pricing and supply chains particularly.
I should say, on the working group, we see national action plans as a continuing process. So I think, using the example of the UK, having launched a national action plan, it's not the end of the road. They have to review it, and I think they promised to review it next year. Now, the question to me was whether we will like or shouldn't we be commenting on the national action plan. Again, where is Phil? This must be on your website, where we have set up something called National Action Plans Repository. But actually, the National Action Plans Repository gives us an opportunity to place the National Action Plan on our website and comment on it. Now, I admit we've only got 3, so we haven't commented on them. But we have sent them out for comments or thoughts for reviews to a number of independent institutions, and we'll draw some of those knowledge to comment on it. So instances where we think particular national action plans are short, we will put our reflections on that. So yes, I agree, we are on the way there, and we'll place it on Phil's website when we get around to it. Then there was a question about grievance mechanisms in national action plans and with gagging orders. Well, I suspect you are referring to a particular company. There's a particular company that is part of a settlement for a particular breach in a particular... What am I doing? I mean, I can't... Well, I don't know if I'm allowed to mention the name of this company, but I imagine you're referring to a particular company that settled for adverse human rights impact and then gagged the community from suing further. Well, there was a statement from our ex-chair, Alex Guakata, on that particular case, to say it is not compatible with the guiding principles. We said that. Now, of course, if this became a standard in a national action plan, we'll follow that same format. No, it's not in compliance with the guiding principles. So again, back to we really need to be a little bit more out there. We need to sell what we do a bit more. And I'm looking at Phil and think you're going to have to give us a bit more dedicated space And then I must confess, I didn't quite catch the question on supply chains and commercial practices. So perhaps rather than trying to answer it, maybe we can catch later, and then I can deal with that. And I'm sorry I missed that.
I've got a question for Michael as well. Michael, the working group is currently reviewing ways of improving access to remedy, but limited, as I understand it, to cases involving gross human rights violations, which would exclude cases like the Shell and BP cases, and in fact a lot of the cases that we do, which I think most people would regard as involving human rights violations that need to be subject to proper mechanisms of redress. So have you got any plans as the working group to extend that inquiry beyond what you've defined as gross human rights violations?
Richard's point about what we call the ZERC study, which is on, and we were very careful to call it a study on egregious violations rather than gross violations, because the gross violations actually has a particular connotation to the ICC, and we really wanted to make it as wide as possible. And to give you a very simple illustration of a case where a company actually took them or bought or took a concession on the most fertile land in a particular country and made all the people now dependent on that company for food. For us, this was an egregious violation of the right to health. So when we commissioned that study, we were not just looking at genocide and war crimes and crimes, and actually we're looking at the entire range and looking at depth. So nearly all of what you do could actually fall under that treaty, in the sense a lot depends upon how extensive and how deep it is, rather than isolated cases. So yes, it'll fit. By the way, there's still, actually you did. I was going to say there's still room to comment on that, so we welcome your thoughts on how we structure that. So the subject is still under review.
Here we've talked about transnational litigation and what the impacts this litigation could have, or whether you've seen impacts on the transnational behavior of transnational corporations in litigation, let's say in the UK, following those companies being faced with litigation in the US. What made me think of it, Martin, when you're talking about the BP and Colombia case, and BP in the US having faced the Gulf oil disaster and all of the problems that they're facing with their settlement process as well as the litigation, and whether perhaps digging their heels in is a knockoff effect from that. So I'd be keen to hear whether you all have seen this in how companies approach litigation and perhaps being receptive to settlement or not. And actually to Michael, whether this impacts how they interact with the working group as well, if they've had a particularly negative or difficult litigation experience, whether you think that affects their reporting to the working group.
It's difficult to always tell, what the impact has been, as they don't tell us that they've totally changed their policy on something because of our cases. I can imagine that it has had a significant impact. In the end, the Trafigura episode that was described in Amnesty's book cost them something like £250 million. The guy was in prison for some long while, the director, and so there was massive impact on the company. On the Shell case, clearly the fact that they've been able to just keep the cases in Nigeria for the vast majority, apart from Paul's stuff until now, and was a slight anomaly being able to keep the cases in the States at the time, whereas I think we've got much more chance of keeping these cases in the UK in the future against Shell. Then I think that will almost certainly change their approach to what's going on. We had a really good judgment the other day as part of the case to say that we can hold them liable for these third-party, what they call bunkering, but basically trying to poor people in Nigeria, when they can't fish anymore because of all these spills, they end up trying to nick the oil. And Shell blames them for a lot of the spills that have taken place. And I think the fact that the judge in our case here held that they could from now on be liable, I think that will dramatically change their policy, because the last thing they're going to want is case after case brought here in the UK. So I think the answer is yes, they change their policy. I certainly hope it's true, but it'd be difficult to absolutely put your finger on it and say this has specifically happened as a result.
That's our experience too. I mean, I would say the same thing.
Thank you. Thank you all very much. We're going to carry on this conversation anyway now in the reception, which is just going to happen there at the back of the hall. And I'm going to ask Phil to come up to the stage to round us all off. And thank you very much to the panel.
Thank you so much, and I think it's a reflection of how interesting that was, that the room's still full despite us being a good 20 minutes over. So I'm not going to be between you and the bar. I was going to do obviously a 15-minute roundup with a delicate and sophisticated summary of all the arguments of today. On the other hand, I think there is one essential thing that I must do, which is thank people. And I'm sure you want me to do that. So very briefly, I wanted to first of all thank all the speakers, because I think, from the start to the finish, we've had an extraordinary exposition of the issues around access to justice, from the most global aspects down to the most grassroots, from the legal through to the civil society approaches to making change happen, to intergovernmental, to private sector approaches. So that's been an extraordinary piece, and thank you ever so much to all the speakers. Secondly, and possibly most importantly, the interns. There's been a vast amount of slave labour involved in this conference, I'd just like to highlight. A vast amount of extraordinary commitment from young people especially, who've made an enormous effort to make this thing happen. That's been the case from the British Institute of International and Comparative Law. Their interns have done a huge amount, from the interns from CORE and also from the Business and Human Rights Resource Centre. So a huge vote of thanks to all those people who gave voluntarily of their time so that this thing could happen. And now in gratitude, you can all give them a job, okay? The second one, the third is to say a big thanks to Karen for doing the video for us. That'll be up, hopefully, on our sites as soon as we possibly can. And thank you very much for that. The third is, another aspect is I have to apologise for you having to slum it in these appalling conditions here today. And so we must thank the Law Society for their generosity of providing this site for us. It's been an incredibly relaxing atmosphere, and in the heat of the day, to be in here has also been great. So thanks very much to the Law Society. And then, finally, because they've thanked me, I want to also just thank Madeline Crosser, the chair of CORE, director of CORE, because without Madeline's extraordinary leadership, this definitely wouldn't have happened. But also Martin McCorkindale for all his efforts as well, being put into this piece as the other sponsor with ourselves. So thank you, everybody. Thanks very much for staying, and I hope you've enjoyed it as much as I have. Thank you very much, everybody.